Hello, my viewers and subscribers. Welcome to another episode of Jamaica Politics Uncovered. Today, guys, I'm going to bring you everything that Vybz Kartel said regarding his Privy Council verdict. He made some statements which I saw on the Instagram page of a New York reporter. Her name is Lisa Evers from New York, and she's given reports on Kartel's case before. If you look on her Instagram page, she made several posts about it since the verdict. So guys, after the verdict, Kartel basically make him case to the court of John Public by, contacting this reporter and saying these things. And me read it and me gonna see what really was said. So there it says, I feel victorious in this very moment as the Privy Council, in their infinite wisdom, understood the assignment and remedied the situation by squashing my conviction. I am now back to being an innocent man in the eyes of the law. A grave injustice was done to me and my co-accused in the original trial, and subsequently, Isat Buchanan et al. Pleaded my cause, and my cries were heard in the highest court of the land. I am also very confident that the Court of Appeal in Jamaica will do the right thing in the name of equity, fairness, and justice, and free us. Some people have expressed their concern to me that a retrial may be ordered, but to them I say, albeit with my limited knowledge of the law, what is there to retry? ? Indeed, the very same Court of Appeal in Jamaica, while upholding my conviction, clearly stated that the lone eyewitness, Lamar Chow, and I quote, severely impugned himself, meaning he is a liar extraordinaire and was not believed by the Jamaican Court of Appeal judges. However, they allowed the conviction to stand based on the cell phone evidence which was shown to be tampered with and subsequently rendered useless and unsafe by analysis from forensic experts hired by my team from the UK. Not only that, police officers in the original trial also admitted that they tampered with text messages using the Cellbrite machine, and even admitted that they used the cell phones which were in evidence to make phone calls and send text messages to various numbers, including my then lawyer, my baby's mother, and to my music publisher. With that being said, the most important point to me is that I am an innocent man. So in reality, I'm not in the least bit worried, as I know I will be acquitted and go home to my family, whom I have not been together with for over. So guys, this is Kartel's Instagram page, and he's been celebrating and acknowledging his legal team and I guess the work that they have done. And he has been speaking out and saying, I am a victim here. I was victimized by the system, and so on and so forth. So right, I just him freedom him want, him not really, credence to the argument about retrial. That's his position, based on what he has said publicly. Meanwhile, him lawyer Isat Buchanan must they go talk something about Obia and St. Thomas. And Muta go hear it. So here what Muta said on radio yesterday.
Court case can take another year or two. So that is the big thing we are going on now. And a whole heap of people feel good. And a whole heap of people vex. But whether you feel good or vex, that now going to change what take place right now. So I better just cool down your temper. Just cool down your temper. Don't raise up your blood pressure. Because it's not going to change the difference. It's not going to make no difference. Remember a little thing though with Isat Buchanan, the lawyer that represent, one of the lawyers that represent Vybz Kartel. Isat, I never know you into God ring and Obia Rasta. Eh? Big liar like you talk about gathering and Obi and all them someday. What kind of madness is that? I tell the people them in St. Thomas but get ready, prepare themselves. Really, Isat, a youth like you, and you talk about my parish, even though I'm not born there, but me understand we go on over the years, and we understand how people view it, but if a youth are coming now, come and tell the people them in St. Thomas but must prepare themselves and them gathering, and I hope I put for the people them, you know. And they said there, I think you use your intelligence and your intellect and evidence and all them things there. If you go through where you go through, if you go to England, go sit down with the Supreme Court. I never know, say, around the corner, how be a business you portray upon the people, them, Rasta. Behave yourself, man. Behave yourself, brethren. We never bring you up for that. We say, we come and know your father. We never bring you up for that, Rasta. A joke business. A joke business, trust me. So the people, them, in the Gaza, I'm not out of Gaza in Israel, you know. I'm going to rejoice all tonight and tomorrow night and the next night and the next night.
Yes, people. So, alright, so the thing there you know, we have to just wait and see. As me telling you yesterday, Isat told the public that he's going to make bail application for Kartel. So, we will see how that goes. In the meantime, the appeals court, them have them thing for sort out and, you know, go back to Kartel and Isat and tell them what it's going to be moving forward. But in the meantime, we should all keep our eyes peeled for whether they will actually get bail, because they don't must get bail. But considering everything we hear, the tampering of the evidence and all of them something there, the jury tampering or rare, maybe they will kind of compensate in being okay with bail. So we will see. Anyway, guys, make sure you're keeping it locked here to Jamaica Politics Uncovered for your latest political news, reviews, and updates. You're not going to get it nowhere else like you get it right here in our unique style of delivery of everything Jamaica politics. Keep it locked here, guys. Make sure you subscribe, you got your notification on, and you're inviting your friends over here. See you in the next video. Take care.
East's murder. A fifth defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct. Secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict. And thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The Board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the Board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the board's view, there should have been no question of allowing juror X to continue to serve on the jury. Allowing juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right to a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of juror X's behaviour. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the board holds that it is not necessary to express a concluded view on the other two grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.